having come to share with us the joy of the birth of a new book, a real physical paper book, a book that can be smelled and touched and held, a book that was produced in more or less this way. Okay, there is a reason I wanted us to watch this clip. Our book came out on November 1st, I think, and we put more than moderate pressure on Cambridge University Press to make sure that it arrives here on time. Alas, last we checked with FedEx, which was like 3 hours ago, the books were resting in Athens. Luckily for us, Thor Newman, Thor, where are you? Thor is there. He's shy. Thor Newman had the foresight of asking Antonio Stenakopoulos, Tony, where are you? You're not shy, right? Who came here from Oxford to pick up a few copies and bring with him. Thank you, Thor. Thank you, Tony. No, but this merely begs the question, why did we care? Why did we care so much to actually have this book? Why does it matter to have and to hold this paper book at this day and age, when it is certain that his virtual doppelganger is lurking behind? Sometimes the e-book even precedes the publication of the actual physical book. And the latter is likely to reach a much wider audience. And we know that the physical book will be chewed by the e-book. We know we live in an age where most of us are obsessed with an ever more omnivorous iPhone or some other electronic apparatus. We know we live in an age where it seems that, well, the book has closed on the book. So why do we nevertheless insist on celebrating this tactile book? And I do not think we would actually be having such an event, clicking congratulatory glasses, if we're not marking the birth of a physical book. I want to begin this evening by proposing the beginning of an answer that I think would resonate not only amongst those of us who are members of a generation for whom curling with a book who does not blink or flashes or directs us away from itself was as natural as having a meal. But also amongst the younger people, the students who I'm so happy to see here in the room. think we all feel, at least at times, that we need to go on an e-diet, that we are wired. And the language being such a wonderful invention, think of the word wired. It has two meanings, of course. It connotes being connected to the internet, but also being frantic, frenzied, frantic, distracted, and finding it difficult to focus, to concentrate. And I think that what the paper book does is to offer us an otherwise lost mental space, an opportunity to pace ourselves. Or as David Ulin, the author of a marvelous little book called The Lost Art of Reading, Why Books Matter in a Distracted Time. The way he puts it is, it gives us an opportunity, and I quote, to regain the world by withdrawing from it, just a little, by stepping back from the noise. And I think we need this silence. We crave not only our injection of immediate data, but also, and increasingly, wish for some moments of silence that feed our all too human need, assuming we are still human, not post-human, not transhuman. Our human need for focusing, for contemplating, for engaging in a meaningful way. Now, Transparency in International Law is a book that invites such an engagement, such reading. It is a book with an agenda. And the agenda is to place the issue of transparency on the international legal agenda. And surely, few issues would compete with the timeliness and importance of putting the issue on the agenda. Recent months, as we all know, have put transparency and secrecy, security and human rights, and mostly their interaction, in the focus of an emerging global debate. Edward Snowden, former NSA contractor employee, removed the veil of ignorance behind which we were all happily unaware of the extent to which the world's most powerful democratic regime, perhaps others as well, regularly breaches our international human rights to privacy, dignity, and freedom from surveillance, as well as state sovereign rights to freedom from intervention in their internal affairs. By the way, Professor Ann Peters had just published a two-part post on EGIL Talk, that's the blog of the European Journal of International Law, offering a concise analysis of the myriad of international legal rules that have been thus breached. But there is another view. It gets better. But there is another view, the view of the security establishment. And this is what NSA Chief General Keith Alexander, who runs the global panopticon, had to say on the matter, and I quote, "I think it's wrong that newspaper reporters have all these documents. It just doesn't make sense. We ought to come up with a way of stopping it. I don't know how to do that. That's more for the courts and the policymakers." So, here they are. Two radically different perceptions fighting against each other in our global arena. One of secrecy, concealment, acting behind the scenes, and enjoying the benefits of others' ignorance. And one of openness, trust, and respect for people's rights and judgment. I think that the first is the perception of the past, even if a die-hard past. The other is that of the future. But this victory of openness over secrecy is all the more reason to look into this new phenomenon. Openness and transparency too can be abused. They too can inflict harm on individuals and societies. By way of example, the contribution Rui Peled and myself wrote for this book. In this contribution, we were asked to respond to a question. And the question was how much secrecy does warfare need? The short answer we gave was, well, far less than what the security establishment would like us to believe. But it does not follow that secrecy is never justified. This is part of the long answer, so read the book. More generally, it is clear that the editors of the book, Professor Andrea Bianchi and Professor Ann Peters, and the contributors, ploughing numerous fields comprising the international legal discipline, have taken upon themselves a task as timely as it is important and challenging. To dissect analytically and think in terms of critical normativity about a new reality, identify its perils, warns us of its risks, and propose the drawing of its limits. It is this contribution to knowledge and thought, coupled with a commitment to human rights, and indeed to the rule of law, that we are celebrating here this evening. Now, when I thought about a keynote speaker for this event, I was thinking in terms of a person who exemplifies such contribution and commitment. And who better than Justice Professor Daphne Barak-Erez? Luckily for me, for us, she accepted the invitation. Moment. Because now I have a pleasure. Now I have this pleasure. Now I'm perfectly aware that Justice Barak-Erez needs little introduction to most people here. But partly because we do have guests from abroad, and mainly because introducing her gives me such a personal pleasure, I will seize the moment. Professor Barak-Erez became Justice Barak-Erez in May 2012. It is often commented in Israel that she is the court's younger judge, which happens to be true. But what this signifies is what she has been engaged with and achieved prior to this appointment, and ergo what still lies ahead. She holds 3 degrees from the law faculty in Tel Aviv University, all summa cum laude nidri ed. And when she left it and us, she was also teaching at our law school since its inception. Anyway, when she stepped out of the academic path to put on the judicial robe, she was Dean of the Tel Aviv Law Faculty, as well as the Stuart and Judy Carlton Chair of Law and Security. In between, she sprang her wings globally as a visiting researcher and visiting professor at, among others, Harvard, Yale, Columbia, Toronto, and Stanford Law Schools, Max Planck Institute in Heidelberg, University College London, Swiss Institute of Comparative Law in Lausanne, and Nehru University in Delhi. Among her public activities were membership in the Council of Higher Education in Israel, presidency of the Israeli Law and Society Association, chairmanship, chairpersonship, it's a mouthful, of the Israeli Association of Public Law, and, well, membership in something equivalent to the PTA of her children's school. Here are facts, probably not written in official websites. Her main research and teaching areas are administrative and constitutional law. She authored and edited some 10 books, some 100 articles, and other scholarly contributions. And recently, she published the 3rd volume of her monumental treatise on Israeli administrative law, this one focusing on economic administrative law. She is also a fantastic friend to quite a few of the good people gathered here this evening. Justice Professor Barak-Erez, it's fun to say it. It rolls naturally on the tongue. The floor is yours. Just a second.
Good evening. It's great to be back here. I really feel at home. And thank you, Orna. I would say that I don't know how to take such a long introduction, a little bit embarrassing for me, although in some way, but I suppose that this can be justified on the basis of transparency. So it was part of the principles of this evening. So this is the justification for, I suppose, for this long introduction. It's good to be here among friends, colleagues, guests. Dear Professor Peters and Bianchi, congratulations on your book. Of course, Orna, my friend, and all the others that I cannot just mention one by one. Today, we are celebrating a book, but we are also celebrating the new frontier of transparency law, its transcendence from the national to the international sphere. States and international institutions are no longer free to practice absolute control over the information held by them, not only on the domestic level, but also from the perspective of international law. In some ways, one would say this is a natural development, a corollary of the generally accepted idea that information is not the property of the entities controlling it. These entities serve merely as trustees that hold the information for the benefit of others. So in some way, this is so self-evident, but nevertheless, attempting to integrate this development into the arena of international affairs presents us with fresh challenges, in some way somewhat different challenges than the one that we deal with as we think about transparency and transparency law on the domestic level. And I will focus my short lecture or address on three areas or three perspectives that I think demonstrate the embodiment of the distinctions between the national and the international spheres in the context of transparency. The first point I would like to address is the relationship between the beneficiaries of transparency law and the duty bearers of that law. When we think about this in the national context, we are used to think about a hierarchy. There is a hierarchy between the state, which is the duty, or other agencies, which are the duty bearers, and the citizens that are entitled to get information from the state. So the request or the claim to get information is in the context of hierarchy between the entity that is supposed to disclose the information and those who are entitled to get the information. Of course, this is a bit simplistic also in the domestic arena, because also in the domestic arena we can think about some context in which a big and powerful corporation is the one that asks the government to disclose relevant information. But if we think at least about, I would say, the classical model of request for information, so we can still see before us this hierarchical relationship between the duty bearer and the individual or the entity entitled to get the information. This is, to the best of my understanding, not the case when we try to apply the discourse of transparency in the international sphere. Because in many ways, the state that is expected to disclose information is only one member among many in the international community. It may be a regular member, one among many. It can be even a relatively less powerful state in contrast to some others to which it has to disclose or before which it has to disclose the information. So we don't follow the same model or the same justification for disclosure that is based on the assumption that the duty bearer is more powerful than those who get the information. The second point I would like to make concerns the relationship between transparency and other enforcement mechanisms of legal norms. My argument here is the following. Transparency in the international arena may be even more important than in the national arena. This is due to the lack of sufficiently effective means that the international community has at its disposal to enforce the binding norms of international law. Of course, I have to ask for the forgiveness of my friends who are experts of international law, but I think we can still say that international law is relatively weaker in comparison to the standard mechanisms of enforcement in the domestic scene. So in contrast to the standard case in functional national systems, infringements of legal norms in the international arena are not regularly brought before a court of law or any other dispute resolution mechanism. Of course, this is very, very general. I know we are all aware of mechanisms of enforcement in international law, but still, there are, I would say, I think, maybe as a domestic jurist, I feel that we can still say that they are less powerful. So what is the connection between this and my argument about transparency? So in the domestic scene, we use transparency in order to use this information in courts. I mean, this is only part of maybe of a broader strategy to bring claims, also by using information that was disclosed. Whereas in the international scene, in many cases, transparency is everything. We want information in order to be able to use it in the context of diplomatic pressures, economic pressures, and not necessarily to use this information in the context of a formal legal dispute. I think that this relatively, I would say, this difference in the two arenas may shed light on the special importance of transparency in the international arena. The third point I would like to make and touch upon is very much connected to some of the pictures that we were presented with in Orna's introduction. In some ways, I think that what we are faced with is the challenge, or is the following question. Is law relevant at all to transparency in the international arena? I mean, we are celebrating here a book about transparency law. And of course, based on what I have said so far, obviously, I'm on the side of those who believe that law is important. But especially in the international scene, we see that transparency is not necessarily connected to law. Maybe to the contrary. Transparency is, in many cases, achieved by extra legal measures, not to say illegal measures. The most influential change in the area of transparency in the international arena has been the willingness of some now famous individuals to disclose state secrets and then attempt to avoid punishment by taking advantage of our globalized world. Such individuals might, for instance, anonymously publish classified information on foreign websites and seek refuge outside their home countries, etc. I don't have to, to describe the process. We are all well familiar with it. So this is an extra legal phenomenon, but it influences the flow of information more than the formal rules of transparency in the international arena. And it is very much connected to the international arena, only because these individuals know that they can find, that they can get away from the legal rules of their national systems, that they can publish this information. So this is not only about the power of breaking law. I mean, we are aware of the fact that law is being broken once in a while, of course. We are sorry for that. But I think this is something that is really constitutive to thinking about transparency in the globalized world, in the international arena. So maybe one of the questions that I would like to pose to the editors is, what is the relationship between the contribution of law to transparency in the international law and the contribution of illegality to transparency in the international arena, and what is the relationship between these two complicated processes. Now, since I'm on the side of those who still want to be optimistic about law and not only about its breaking it, I would like to make a more general statement and more broadly point to the success of the transparency revolution. And I think that this success can be fully assessed by pointing at the fact that currently we do not question the right of transparency anymore, not seriously. At this point, I think both on the national and the international level, we mostly debate the scope and the exceptions of transparency. Transparency is given. This is the assumption. This is the starting point for every, I would say, relevant new discourse. Moreover, quite often, transparency is not only given, is not only, I would say, an understandable and clear legal duty, but sometimes, in many cases, we see that information is disclosed as a matter of choice, as a matter of independent choice of institutions that believe that transparency can also benefit them, that they want to be part of the transparency discourse, and not only because they are obliged to disclose information. And I think that this is also very apparent in the international arena. Thus, in the new phase of transparency law, the one we are celebrating today, we no longer need to justify the need for transparency. We usually have to justify only its limitations. Thank you.
Thank you, Daphne. And we are very fortunate to have with us the two editors who hopefully will respond to your question. Professor Bianchi and Professor Peters. It's nice to have a book edited by two people. I personally like collaborative work. It has the potential of synergy, and it is less lonely. As part of the editorial process, they've invited all contributors to a retreat in a lovely Swiss village in the Alps, which was wonderful. Perhaps they would like to share, as part of what they tell us, the editing experience with all of us as well. I would like to begin by introducing Professor Andrea Bianchi. Professor Bianchi is a faculty member of the Graduate Institute of International and Development Studies in Geneva. He previously taught in the Catholic University in Milan, University of Parma, and at the Bologna Center of the Johns Hopkins University. His international legal scholarship covers a wide range of fields, including international human rights, international economic law, the law of jurisdiction and jurisdictional immunities, international environmental law, state responsibility, the law of treaties, normativity and lawmaking, International Humanitarian Law and Terrorism, which is also the title of a book he published in 2011. It came out by Oxford University Press, co-authored with Yasmin Naqvi. And of course, Transparency and International Law. And Andrea also chose the cover for the book. And I happen to think that the book should be judged by its cover. And the cover is wonderful. Andrea, please. Please go.
Well, ladies and gentlemen, good evening. I wish to make our gratitude also on behalf of Anne, wholly transparent. So from the bottom of our hearts, Orna, thank you very much for organizing this, and thanks everybody else for attending this event. Now, I think it is an irony of sorts that just a few weeks before the book came out, I had to move into the new campus of the Graduate Institute in Geneva. And the most conspicuous feature of this new campus of the Graduate Institute in Geneva, which is made of 6 buildings that are called petals, which is odd because there is no flower, no stem, but they are called petals nonetheless. But the most conspicuous features of these buildings is that they are wholly transparent, meaning that you can actually look through them. And also, my office, which is the worst part, was fully transparent. And you could actually look through, which I actually hated, as, you know, one does not necessarily like to be seen in the intimacy of his own office, picking his nose, stretching his legs, doing even worse things. So I vehemently protested against the director of the Institute, and I said my continued presence at the Institute was dependent on protecting me against transparency. The director eventually yielded to my request, and I had a thin plastic film glued to my glass window door that blurs the view from outside and does not allow you seeing the details of what's going on inside. You still get the basics, but not the details of it. But most of my colleagues gave in to the social pressure to keep the transparency of the door, which was justified on grounds of unspecified technical requirements. We must let the light pass through the entire 6 petals. Unspecified security reasons, but whose security is certainly not mine. And fourth, consistency with our new policy of sexual harassment. So I got the thin film glued to my door so I could eventually take up my bad habits in my office. But I realized very well that I had done something which was against the prevailing cultural mode, and that did not make me any more popular in my community. Because it is practically impossible to speak against transparency. Even the story of this book attests to this. Anna and I got enthusiastic peer reviews, which is almost unprecedented in the profession, because peer reviewers by definition and by vocation must shoot at you. Nonetheless, this time they were all full of praise for us and for the book, which made me suspicious and caused me to volunteer to look at the darker sides of the concept of transparency, which is what I do in the introductory chapter of the book, to which now I briefly turn. Transparency has become one of the fundamental distinctive traits of our contemporary culture. It is recommended by psychologists to recover trust after infidelity, and it is increasingly imposed on banks and financial institutions. Medical practice leans dangerously towards transparency, and you may unceremoniously be told that you are going to die just for the sake of transparency. Worldwide campaigns have been launched in the name of transparency by not-so-transparent organizations such as WikiLeaks against the abuse of power by states. Transparent portable phones present one of the most pressing research challenges for electronic gadget designers. We demand transparency of our partners, our colleagues, the City Council, the government, international organizations, the Security Council, what have you, short of God, whose will is scrutable, transparency is the mandate of everyone. And transparency epitomizes the prevailing mores in our society and becomes a standard of political, moral, and occasionally legal judgment of people's conduct. A narrative of transparency permeates our daily life. It is deeply rooted belief. Transparency is all around us. As is also the case with human rights, it is almost impossible to find anyone who would speak, in public at least, against transparency. No one would ever dare contest something that is universally perceived as a good value. And in contrast, the opposites of transparency, such as secrecy and confidentiality, have taken on a very negative connotation. Although they remain paradigmatic narratives in some areas, overall they are largely considered as manifestations of power and its potential abuse. The simple truth is that we no longer see why one should be secretive about their own business, whatever that business is. All the more so if the activity in question concerns the administration of the public good. Not even in such areas as security and public order is public opinion particularly in favor of transparency and restrictions attached thereto. Overall, the world we aspire to is a transparent one. And the purpose of these brief remarks is to call the wisdom of this aspiration into question and to investigate into a few dark sides of transparency by showing that some of its promises may just be illusory. Now, we deal with transparency in international law, and we hope to add something to the current literature about this. Primarily, we aim also to put it on the map. But it's quite extraordinary to realize that up until now, at least, transparency in international law is always treated with a lot of caution. Transparency as practice, rule, principle, norm, is generally seen as developing or emerging. Whatever its nature, it is usually described in the statu nascendi as something that is just about to emerge, a potential that has not yet turned into actuality. However, its righteousness and its desirability is hardly ever called into question. Its advent is a matter of time, at least according to those who look at international law as a narrative of unhindered progress. So I dealt primarily with the concept of transparency, and I looked at transparency primarily as a concept, which leaves me the privilege of leaving all the difficult questions raised by Justice Professor Barak-Erez to my colleague Anna Peters, who will be eternally grateful to me for this. And I will continue saying a few things about transparency as concept. Because dealing with transparency as concept presents several advantages. It allows an evaluation of its contours without the strictures of any value-laden a priori definition, and it makes it less difficult to imagine that the normative prescription may exist in our mind, irrespective of any technical reference. Indeed, however difficult it may be to define it in precise terms at law, we do possess an intuitive representation of what transparency is. And I resorted to a metaphor in order to grasp the concept of transparency, because I believe that metaphors are powerful tools of mediated knowledge that may help us to understand better certain realities, particularly when they provide mental links and associations to our everyday life. And the obvious metaphor to deal with transparency is a clear window that you can look through. And yet, even so, the idea of transparency can remain very elusive. Do I have a clear view if I look through the clear window? What if my view is blurred? Is that what I see reality, or just a mental representation of what I expect to see? Does it make a difference whether the window is open or closed? Is transparency equivalent to nothingness? What if the outside is dark, or if the sun is shining? Would what I see then not be different? To what extent could different types of window glass alter my perception of what I see. Is standing behind a perfectly transparent window equivalent to standing outside? Is what I see not dependent also on the position in which I am behind a window? By moving a few inches either side or by turning my eyes up or down, left or right, what I see can be remarkably different. Now, I could probably go on and bore the audience with further questions related to the fairly simplistic and arguably misleading character of the window analogy. The truth is, however, that despite its fallacies, we still find the image of the window a good example of what transparency stands for. After all, we expect to see things behind a clean window. We expect to have access to reality and apprehend it through our sight and comprehension. In other words, we expect to have unhindered access to physical data and information. We expect transparency to open a window on information. But the expectation of seeing through the window, or through any other transparent material for that matter, can be misleading, particularly if one expects to seize raw data or information in the purity of their pristine state. The problem with grasping the essence of such data or information is that in reality there is no such thing to be grasped, as data does not speak for itself, nor does information. In fact, the availability of information is tantamount, the idea that the availability of information is tantamount to empowering people and the people of the world against power and its many agglomerations is a little bit simplistic. And I think that the WikiLeaks saga remains a perfect allegory of the use and misuse of information in the name of transparency. Throughout the whole process, if you just remember the process, the disclosure and publication of materials has been carefully orchestrated, thriving on cleverly raised expectations and on artfully created perceptions of righteousness. From the first major breakthrough in April 2010, when the Baghdad airstrike video was released, through the time of the Afghan War diaries, and the diplomatic cables were released in small and successive quantities in September 2011. By a constant build-up of expectation and a continuous process of anticipation and speculation, WikiLeaks succeeded in creating an extraordinary momentum for transparency. The culmination of the story, with the uncensored release of over 250,000 documents in September 2011, is also paradigmatic. What had been previously carefully selected, leaked to create expectations, and eventually published with a sense of perfect timing, was now unselectively released, as if to set in motion uncontrollable forces that would flood the whole world. Amidst the turmoil of public outcry, the picture was blurred, and it was no longer clear how one should orientate in such an overwhelming flow of information. Well, I suppose that the gist of the story is that information is not a synonym for knowledge. Does one know better about events simply because one has more information? If this were to be the case, why is it then, as the New Yorker's cartoonist once famously put it, in the information age nobody knows anything anymore? The ambiguity inherent in the concept of transparency as information and the many tensions it harbors can be further evidenced by another practical illustration, that of the credit rating agencies and their self-proclaimed mission to rate the financial standing of states and their bonds. Now, quite apart from any other issue concerning the actual independence and impartiality of such agencies, one wonders the extent to which they actually operate to foster transparency to the benefit of the investors and of the market. For instance, the fact that some of the information on which the rating relies is of a non-public nature, or the fact that little transparency exists within such agencies that are then expected to act as trustees of the community. The perceived technical character of the credit risk assessment ignores the fact that the data, again, does not speak for itself and needs to be evaluated in context. Now, the rather unsettling truth is that to make information available is not synonymous with transparency. In and of itself, information is ambivalent. There is no inherent value in it, as its value is highly dependent on context. Information can be, and in fact is, used instrumentally. It can be used for different, even conflicting purposes and to attain different goals. The analogy of the clean window that most of us would use to grasp the concept of transparency can be misleading. At worst, it can turn out that it's not just a misperception, but an illusion. And that's my other point about transparency as an illusion. We generally hold a very simplistic idea of what an illusion is. To most of us, an illusion consists of believing something which is not true, or to be deceived by a false belief or perception. Insights from other disciplines clearly show that there may be more to it than we simplistically tend to think. As I mentioned at the outset, we now live fully immersed in an aspirational world of transparency. Transparency is the ultimate frontier in art, design, and technology. Besides the aesthetics of design, transparency also performs more sophisticated functions at the interface of society and professional culture. The myth that technology can disappear completely and put the viewer or user in touch with reality lies at the basis of current efforts to make the interface invisible and to offer the illusion of the three dimensions. Even if they push their strategy to the extreme, transparency designers know very well that there is a relationship of indirect proportionality between the simplicity that transparency inevitably brings about and the ever-increasing complexity of operating systems. In other words, transparency comes with the price of oversimplification. There may be, of course, other explanations for illusions, and I consider some of them drawn from psychology and psychoanalysis, which are quite interesting, but we have no time to go through them. Just let me conclude on this point, that transparency can be illusion in a myriad different ways. From the above insights, one can only infer yet another observation about transparency, namely that transparency is intimately related to knowledge. The process of interaction is a complex one, and what we come to know by transparency is determined by a variety of factors: our wishes, our inclinations, our predispositions, our professional bias, why not, and so on and so forth. What we see through the window of transparency then becomes what we are trained, forced, persuaded to believe or to make out of what we see uncontestably. This process is also about power, and this is my concluding remark: transparency as power, or power knowledge. Power is diffuse and pervasive, as Foucault used to say. It is all around us in society, and it does not always take the shape of physical coercion or manifest itself in obvious ways. Those who create and shape knowledge at all possible levels possess power. Availability of and easy access to information are part of the equation, as knowledge is formed on the basis of information. But discursive strategies elaborated by knowledge-wielding bodies are controlling. Transparency is part of such strategies, for better or worse. And the different epistemic communities that create the discourse in the various areas of international law make use of transparency, or of its opposite, to shape their discursive policies. Transparency, however, remains almost invariably confined to its ancillary role. It has no essence in and of itself. It is chameleon-like and may change depending on context. It would be simplistic to maintain that there is no cultural constraint on epistemic communities. Nowadays, transparency is more in keeping with community expectations, particularly as regards issues of governance at national and international levels. Although in some types of discourse, such as national security, secrecy and confidentiality remain the prevailing paradigm, they are increasingly challenged in the name of transparency. The easy embrace of transparency as an approach to many an issue, including decision-making and legal processes, also hides what has been termed a defect of value. The frustration with the lack of visibility and fairness in international law and politics makes the call for imposing transparency compelling. A coercive ideological transparency, however, is unlikely to make the difference or to make up for the absence of other substantive values. Moreover, that's my addition, a world in which ideological imposed transparency rules would be a world where there is less space for the transient, the risky, the bold, and the uncertain. To set out to explore the less edifying and often dark sides of transparency was meant to me to warn against the risk of oversimplification. What secrecy does overtly, transparency can do surreptitiously. Our inner secret desire for transparency is part and parcel of our perennial quest for the truth, the quest for the holy grail of good governance and democratic rule, legitimacy and accountability, justice and fairness to all. Once again, the inconspicuous character of transparency comes to the surface. It is always an attribute, an accident to substance, an instrument to purpose. Ultimately, it is a mirror more than a glass, in which our visions materialize and our desires come true, a visual illusion, the power of which we find hard to resist. The power of illusion hardly hides the illusion of power. And that's how I conclude in my introductory essay. It is a sound reflex to beware of both. Thank you very much.
Thank you, Andrea. It was fascinating. Professor Ann Peters is our last speaker tonight, and I'm going to introduce her in a somewhat personal manner. Is that okay, Anne? We first met in Florence, I think in 2007, at the first meeting of the newly created Scientific Advisory Board of the European Journal of International Law. We had a lovely dinner together in Cibreo. The restaurant was recommended by Professor Eyal Gross. Eyal? Yes. Great restaurant. And but the point is that it was to my discredit that I did not realize at the time that she is one of the most prominent, prolific international legal scholars around. Mea culpa, no doubt, but I've amended my ways. So now I know better. We've met several times since, including in the retreat in the Alps. At the time she was chair of the Public International Law and Constitutional Law at the University of Basel in Switzerland. And this institution where she previously served as dean and eventually as Dean of Research. Then we met at various meetings of the European Society of International Law, over which she was presiding. Last time we met, it was this summer in Berlin, where she was just wrapping up a year as a fellow at the much coveted Center for Advanced Studies, the Wissenschaftskolleg, or WICO, and on her way to a new position as director of the Max Planck Institute of Comparative Public Law and International Law in Heidelberg. Professor Peters' scholarship centers on the core, on the foundations of the discipline. In over 10 books and hundreds of articles and other contributions, this is quite evident. European and comparative constitutional law, constitutionalization of international law, history of international law, international European and national human rights law, global governance. Now she's working on a book on global animal law, and of course transparency. And it is a pleasure to have you, and the floor is yours.
Experience. I thank also to other authors. Not all authors made it here to our event, but some, Tore Neumann and Antonios Tsanakopoulos. And of course I thank Andrea Bianchi, my dear co-author, for leaving me all the questions. And I thank Justice Barak-Erez. And I really regret that the book is already here, because if it weren't here, we could have forced Justice Barak-Erez to put her chapter in this book still. But I'm afraid that this is too late now. Second edition. Yes, Antonios always has good ideas. So we take you hostage for that. So let me just briefly hook up to what Orna and the other speakers already mentioned. The current events, the current surveillance activities, I think, have illustrated exactly what is our topic. They have reversed the liberal quest for transparency of governance institutions as opposed to privacy of citizens. They have rendered the citizens transparent and have all done this in secrecy. Actions of Edward Snowden and others are illegal under domestic law as it stands, even criminal. And now I will come to your question. The question of the book is whether there might be some higher principles, higher law, principles of legitimacy, or simply principles of international law which might justify or excuse, give a defense to the criminal activities of bringing to the light all kinds of surveillance programs. So this would be a very traditional answer, resorting to a hierarchy of norms, to a possible hierarchy and to a possible priority or primacy of international law vis-à-vis domestic law. You have all spoken now about the transparency discourse and that it is now commonsensical to speak of transparency, to request transparency. Justice Barak-Erez said that it is nowadays considered as our right. But I think that in international law, within the international law discourse, we are not yet as far. Although I have spoken in my concluding chapter of a transparency turn of global governance, a quest vis-à-vis the international institutions to become more transparent, and this request has also been honored to some extent, but skepticism is still quite obvious. For example, at our workshop in Thun, we had all kinds of hardcore international lawyers, including our dear Antonios Tsanakopoulos, who were very doubtful about the law quality of this ostensible principle of transparency. But there are, I might just recall some encouraging documents, which are, however, more or less soft law documents. For example, you have a WTO report on the transparency of the WTO, the Sutherland report, which discusses reforms and has one big chapter on transparency. Also, the World Bank in 2010 issued a document on a policy on access to information. So these are not treaties, but more or less internal documents of the organizations themselves. But there are also international treaties which request transparency. For example, the Aarhus Convention on Environmental Information. But this Aarhus Convention does not demand transparency by any international institution, but by states who are obliged to furnish information on environmental issues. Then within the European Union, which is of course a very specific player, there is a transparency regulation which grants EU citizens access to documents. Just 2 weeks ago, the European Court of Justice issued a new judgment on that regulation, a judgment in which an NGO requested access on a lawmaking process within the EU. Actually, it was a lawmaking process and not only administrative documents. And the court here, and this is quite important, just 2 weeks ago, said that also lawmaking documents within the lawmaking phase, proposals by member states, have to be opened up to the public, even also giving the name of the member state, disclosing the identity of the member state who has made a proposal. So there are soft law documents and hard law documents on transparency, and the question that we asked as lawyers at our workshop and throughout the book was, all among other questions, whether we really have an international legal obligation and whose legal obligation it might be to be more transparent. Is there any general treaty prescribing transparency all over the international governance institutions? No, there is no such treaty, and probably there cannot be such a treaty because this would be much too broad. and unflexible, so not desirable. Then the next question might be, in a very traditional approach, is there any customary law obligation for some international legal persons to become transparent? We would need a practice and a legal opinion in that regard, and none of our authors on the 500 pages could detect such a customary general norm of transparency. And maybe there is a structural problem with such a norm, because in order for a concept or principle to be legalizable, to be conceivable as law, such a principle would have to meet some structural preconditions. It would have to be sufficiently precise to generate an obligation and to be able to be operational, to be implemented at all. It would clearly have to define the creditors and the debtors of such an obligation. And all these conditions do not seem to be easily fulfillable with regard to the concept of transparency, whose illusionary and fluffy and vague character Andrea Bianchi just highlighted. As a result, it seems difficult to argue that transparency is an international norm, of a legal norm, and maybe it can never become one. But again, maybe this statement is not so relevant, because the ability of a principle to guide behavior might not be so much dependent on whether it can be put into the traditional boxes of international legal treaties, custom, or general principles of law. What are the functions of transparency on the international level? Justice Barak highlighted what she considered to be crucial differences between the international and the domestic level. And I think that these differences were well taken, but there are also similarities, and there are also functional similarities. I think that on the international level, the idea of transparency fulfills at least 3 clusters of functions. One is, it has also been mentioned by Andrea, good governance, rule of law, foreseeability, accessibility, legal clarity. That's one cluster of functions. The second cluster is to secure accountability, participation, and democracy. And the third cluster of functions is also important, notably in the financial sectors. We studied that in the chapters on the World Bank and also concerning investment law, to make an institution more effective and more efficient. Transparency is a vehicle for that too. I now, in the last minutes, will only speak about transparency and democracy. It's clear, it's obvious, that democracy needs transparency. And the classic statement on this issue was tendered by James Madison. I quote the Federalist Madison: "A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives." End of quote, Madison. So transparency is obviously a conditio sine qua non for the consent, for the informed consent of the governed. It is critical for uncovering abuses and for defending interests. So transparency might, to some extent, alleviate the democratic deficit of global governance. But transparency in itself, of course, does not bring about democracy. It is solely a precondition for possible democratic procedures. Because transparency facilitates control and scrutiny, it might help to improve accountability. But one question is, to whom the accountability of international law and policy makers, notably the accountability of international organizations, should extend? To whom are they accountable? To who should they be accountable? Only to their member states? Or to all states? Or to a global citizenry? Who are the relevant and legitimate actors who should receive the accounts? That's a very important question, one which has not been answered in the book. Most of all, there is one important objection which can be raised against this idea of rendering international organizations more accountable through transparency, and Andrea also touched upon that. Isn't transparency just a surrogate replacing the much more difficult substantive issues, the issues of democracy, of good governance, of economic efficiency, of social justice and rule of law. Yes, I think it is. There is also a danger that certain types of transparency will degenerate to empty titles of legitimacy, to a kind of ersatz legitimacy. The debate on transparency masks the other issues which are behind them. But the gist is that while transparency is indeed an ersatz, only a substitute or a surrogate, it is, however, I think, a necessary one because it replaces, in a global and pluralistic political space, the unattainable certitude and conviction about the right and proper international law and policy through a procedural device which allows everyone to form their own opinion on matters of global governance. Still, of course, transparency has its drawbacks. The drawbacks, I think, have been quite highlighted during our the remarks which have been made before. I think maybe highlighted a little bit too much because we are not yet there in international law. But still, let's speak about the problems. The problems are, first of all, the intrinsically negative effects of transparency, notably the dangers posed by transparency to the quality of deliberations, especially diplomatic deliberations, treaty negotiations. At Tuesday, I was at Hebrew University Law Faculty, and there came the instinctive reaction by our dear colleague, Professor Roby Sable, who is also a diplomat and an experienced member of the Foreign Office. He immediately said, well, diplomatic negotiations cannot work if they are guided under, if they're conducted under public scrutiny. I won't go into that anymore here now in our few minutes we have. The other type of problems are countervailing interests, legitimate interests such as security interests, privacy interests, business secret, trade secrets, and all these countervailing interests must be balanced against the pros, the advantages which transparency offers. Third, but that's of course trivial, transparency policies, as all policies, have costs. They cost money, and there may be simple practical restraints which make transparency policies unfeasible due to time and space constraints. Fourthly, transparency may only be simulated, and it can be simulated through data flooding, drowning the recipients in disclosure, and also to outright disinformation and propaganda, which is of course a traditional means in international relations. Another important point is that transparency measures can be circumvented. The legal and political actors might hold secret meetings behind the public meetings, they might keep secret files apart from the public files, or they minimize record keeping altogether. And this is, of course, actually what's happening. Think of the WTO green rooms. And if these circumvention reactions are the foreseeable reactions to transparency policies, then the entire policy might be rendered ineffective or might be counterproductive and backfire and thus create more intransparency. This is a very brief overview about the functions and the drawbacks of transparency, and this has led us in the book, or me in the concluding chapter specifically, to offer some policy recommendations. De lege ferenda, international law and institutions should be rendered more transparent. This is my conclusion. The current trend should be basically continued and reinforced. However, because of the mixed effects of transparency, any move in that direction needs to be qualified. Total transparency of international law is neither appropriate nor realistic. International law and policymakers should treat transparency as a variable of international and legal design, and they need to balance the potential negative effects against the positive effects. The second point is that I think that a legal presumption of transparency can already be acknowledged. Justice Barak also mentioned that this is a kind of a tacit assumption, and I think we could shape it or conceptualize it as a legal presumption in favor of transparency. On the basis of such a legal presumption of transparency, That would mean that the non-release of documents, the closure of meetings to the publics, must be specifically justified on the basis of legal exceptions, and these legal exceptions have to be clearly defined and circumscribed prior to the fact. And these exceptions can only be granted by stating the reasons for them publicly. That means that the presumption also places the burden of explaining and of proving the need for secrecy on the institutions themselves and not on those outsiders who request access to documents, to files, to meetings, and so on. A third point is meta-transparency. Tore Neumann and Bruno Zimmer, in their chapter on the judiciary, have examined that with regard to international dispute settlement, and have also found that there is a kind of principle in that field, if I'm not wrong. Tore is already frowning that I'm saying that. I think we can generalize that idea of meta-transparency. Meta-transparency means that the reasons for any intransparency and also the substantive and temporal scope must itself or themselves be transparent. In other words, the question as to whether, how much, and for how long intransparency or secrecy is warranted in a specific field, for example, the need for a closed-door debate, the circumscription of exceptions, possible reform of the policy, all that must itself be subject to a public debate. That is meta-transparency, and thereby an element of public accountability for the intransparency itself will be introduced. My conclusion is that the transparency turn of global governance, what I call the transparency turn of global governance, manifests a paradigm shift of international law as a whole, a paradigm shift from international law's private law character to a more public law character. And now this is difficult, and when I explained this to one of the doctoral students at Heidelberg, they said, well, we don't understand anything. So I'll try now again to explain this. Traditional international law, mainly being interstate law, law between states, has long been conceived, you surely know that, as private law writ large. Hirsch Lauterbach has written of it, and that's a famous quote by Thomas Holland, private law writ large, that it is based on analogies of private law, and the states are conceived of as private persons who interact, for example, by concluding contracts. And my claim is now that international law has been more publicified in three senses. The first sense we need to recall the traditional distinction between public law and private law. And this distinction between the two branches of law ultimately stem from the different logics. The logics of Justitia Distributiva, realized through distributive public policies, that's public law logics. And on the other hand, you have Justitia Compensativa, compensative justice realized in the private sphere on the market through exchange. The emerging transparency norm within international law, with its quality as an enabler and to some extent as a proxy for accountability, participation, and global democracy, is, I submit, currently strengthening the element of global distributive justice within international law. It is a law in the global public interest for the public. That's the first sense in which the publication, the rise of the transparency idea has rendered international law more like public law. International law is being transformed into a more public law also in a second sense, because it is even more becoming a law which constrains political authority and which seeks to reconcile the exercise of global political authority by international institutions with individual autonomy. And finally, international law is being made international public law in a third sense. It is made, if it is transparent and to the extent that it is transparent, under the scrutiny of the public, though it is made through the public, even if it is not fully made by a global public. So that's my conclusion. The transparency of governance is only a necessary condition and not a sufficient condition for bringing about participation, accountability, and possibly democracy in the global sphere. And there's surely no automatic progress from global transparency to democratic forms of self-determination of a global citizenship. Further books to be written by Orna, Roy, Andrea Bianchi, by you, further books must analyze other juridical building blocks such as participation, contestation, solidarity, and other building blocks to make suggestions to help realizing fair global governance. Thank you.
Okay. Thank you, Anne, so much. For me, meta transparency has to do with not information, with knowledge. Knowledge and power. Now we all know that knowledge and power are related. We have known it long before Bacon said that knowledge is power, and before Foucault taught us that they are symbiotic, that in knowing we control and in controlling we know. We know it's a thing since we projected into the Almighty two fantasies. He's not only omniscient, is he? He's also omnipotent. But we, thankfully, are merely human, at least for the time being. Our humanity requires that there should be this as a presumption, that power be controlled, and ergo, that knowledge be shared. I think this is the agenda transparency in international law is advancing. I think it is a humanistic project par excellence. Please join me in thanking our speakers. Special thanks to Orsa Dan, who is the executive manager of the Emile Zola Chair for Human Rights. And thank you all for fantastic assistance in this evening. I thank you all for being here. Have a marvelous weekend.